Hi drivers, this is Paul Taylor here once again from Truckers Justice Center. I'm the Chief Trial Attorney at Truckers Justice Center. We're a law firm that represents truck drivers in disputes with trucking companies related to wage claims, wrongful firing, owner-operator skim cases, bad DAC reports, and things of that sort. Today I'm going to talk to you briefly about a common misunderstanding in transportation in the trucking industry, and that is that drivers believe there's some sort of legal protection if they refuse to drive because the truck they've been assigned to drive doesn't have a working air conditioner. Well, that's just simply not true. Sort of. An air conditioner is not a required item under Part 393 of the Federal Motor Carrier Safety Regulations. There is a regulation that says all parts and accessories which may affect the safety of operation shall be in working order at all times, but there's been no definitive case that I'm aware of which says an air conditioner is a safety required item. So in general, if you refuse to drive because the air conditioner is not working or not working well, you probably have no legal protection under the Surface Transportation Assistance Act. That is a statute which says no person may retaliate against a driver because a driver refuses to drive because driving would violate a commercial vehicle safety regulation. So generally, no protection for refusing to drive without a working air conditioner, at least no legal protection. This isn't a matter of how I think the law should be or how I want it to be and whether or not a driver should refuse to drive on a 100-degree day without an air conditioner. But the fact is, refusing to drive without a working air conditioner is not legally protected under the law. However, as you know, if you hold a CDL holder, and you probably do if you're watching this video, there is an ill or fatigued driver rule. And that rule is at 49 Code of Federal Regulations, Section 392.3. And that says, in essence, no driver may drive and no company may allow or require a driver to drive while that driver's ability and alertness are so impaired due to illness, fatigue, or some other cause as to make it unsafe to drive. So if the heat is getting to you because there's no air conditioning and you simply can't drive another foot or another mile, or maybe you can only drive a little bit more because you're exhausted, you're dehydrated, you've taken all steps to stay cool, but it's simply not safe to continue driving, then yes, you are legally protected, not for refusing to drive without an air conditioner, but refusing to drive when you're so impaired or so likely to become impaired due to illness or fatigue or some other cause as to make driving unsafe. Now, certainly, that DOT regulation protects you against anticipated fatigue or anticipated illness due to heat. But to make a blanket refusal to drive without air conditioning is probably taking a risk you may not want to take, and that's a risk of getting fired. But if you are to tell the employer that, hey, the forecast is for 100 degrees, or better yet, at least start the workday, and when you get close to the terminal, if you're wiped out due to heat, that it's unsafe, not just uncomfortable or terribly uncomfortable, but unsafe, you are protected, but you should tell the employer, you must, in order to have protection, say, it's too hot to safely drive. I'm exhausted. I'm fatigued. I'm feeling clammy. I've got a headache, all because of no heat. It's probably likely to get the air conditioner fixed in your vehicle too, because they don't want drivers booking off due to heat. Thanks. Have a nice day. Be safe out there.